Professor Moses is here, and Dr. Arindam Pal is here. Who is going to be the chair of the first session. I think it's a good time to welcome you all. So if you can see me, so my name is Kripa Bandhu Ghosh. So I am one of the organizers of SAIL, and on behalf of all the organizers of SAIL, I warmly welcome you. So as you know that this is the first edition, or basically the first iteration of SAIL, which is basically the Symposium on Artificial Intelligence and Law. So we are highly privileged to have renowned artificial intelligence and law experts, either as panelists or as invited speakers. We have a lot of basically renowned people working in the confluence of artificial intelligence and law, aimed at a better future of legal applications that can touch human life. We have representatives of some of the leading forums of artificial intelligence and law, for example, ICAIL, and we have representatives of some of the leading artificial intelligence venues like CGIAR, and we have representatives of the TREC legal track, which supposedly set the benchmark for evaluation of information retrieval in the legal domain. So we have top Indian and foreign academia represented. We have representative of the Indian Law Ministry. We have top representatives from basically law corporate from India and abroad. We have some exciting talks coming up to basically touch upon a few. There will be something on AI ethics, electronic discovery, data protection, question answering, and many more. And we have two exciting panel discussions with themes on Indian law industry and future of law in India. So I welcome you all, and we have a wonderful audience from all over the world. So we have more than 700 registrations. So as I saw that we have both faculty members and students from law and artificial intelligence. We have law practitioners from all over the world. So I was looking at the country-wise distribution also. So maximum of them are from India, but interestingly, we have representatives of all the continents except Antarctica. Like we have registration from Singapore, Malaysia, Nepal, UAE, Bhutan, Sri Lanka, Bangladesh, Pakistan, China, Thailand, Japan. We have from Austria, Germany, UK, Spain, Canada, US, Australia, Kenya, Egypt, Nigeria. We have from Argentina, Brazil, Peru, Jamaica, Mexico. So hopefully after this particular edition gets popular, we will have some interested people from the missing continent, that is basically Antarctica. So next time we can have someone from Antarctica also. So thank you very much everyone for this wonderful and overwhelming support, and we are hopeful that you are going to enjoy the sessions. So as you this is basically for the attendees. You may see that you are by default your videos are switched off and muted by default. So this is just to maintain the decorum. So we are really sorry about it, but you can ask your questions. For that, please use the question answer option and not the chat option. So all along the talk, the questions will be collected, And I mean, since we have only 10 to 15 minutes of, I mean, question answering session, the chair will basically look into the questions and some of them will be asked to the speaker. So, I mean, as you can already look into the program for today. So we start with Professor Moses. We'll be talking on AI ethics and AI regulation, asking all the wrong questions. Then from 12 IST, basically 12 noon IST, we'll have a talk by Professor Guido Governatori. Then from 15:30 IST, we will have a talk by Professor Susan Verburn. I'm sorry if I'm not sure about the correct pronunciation. So the title of the talk will be explainable legal information retrieval. And finally, at 18:30 IST, we'll have a talk by Dr. Dave Lewis. The title of the talk is Modeling and Minimizing Costs in Technology Assisted Review for the Law. So thank you very much, everyone, for joining. I welcome you again, and I will now hand over to Dr. Arindam Pal for chairing the first session. Thank you very much.
Thank you, Dr. Kripabandhu Ghosh, or Kripa as we know him. So I'll call him Kripa, and thank you for introducing this symposium on AI and law. So we are looking forward to have a very exciting discussion and brainstorming over the next 5 days. And as I looked at the the program, there are some really exciting talks that I am also looking forward to attend. So today, the first talk will be by Professor Lyria Moses from UNSW Sydney. So Lyria will talk on AI ethics and AI regulation, asking all the wrong questions. Now that is quite interesting because I thought that instead of asking the right questions, why she will be asking the wrong questions, but it will be useful to know what are the wrong questions and what we can learn from asking those wrong questions. So I'm really looking forward to that. So Lyria is the director of the Alliance Hub for Technology, Law and Innovation and professor in the Faculty of Law and Justice at UNSW Sydney. She is also the co-lead of the Law and Policy theme in the Cybersecurity Cooperative Research Center and faculty lead in the UNSW Institute for Cybersecurity. She is on the NSW Information and Privacy Advisory Committee, the Executive Committee of the Australian chapter of the IEEE Society for the Social Implications of Technology, and she is a fellow of the Australian Academy of Law. So before I hand over to Lyria, so I want to say a few protocols about this symposium. So first of all participants will be muted by default and have their videos turned off. So please post your questions under the Q&A section only. Questions will be answered at the end of the session by the speaker, but you can ask the questions at any time. And also please have a look at the questions that have already been asked to avoid duplicate questions. If you have any audio or video problems, you can raise that using the chat window. So without much further ado, I hand over to Professor Moses. Over to you, Professor Moses.
Thank you very much. Let me just see if I can get my slides up. Can you see the slides?
Yes, we can see it.
Okay, wonderful. Look, thank you for having me, and thank you for the introduction as well. The title of this talk is somewhat confusing, so let me explain a little bit about what I'm going to be talking about. To understand the legal framework for a particular technological practice, such as artificial intelligence, you need to do more than find the legal rules or regulatory instruments that mention that practice. In particular, you need to understand how current laws apply in the context of that new practice. But you don't need to be satisfied with that. So you might think, okay, we need to change the way this law works because its application in this context doesn't give us the kinds of answers we want. So we can change it. And then when we do want to change it, do we want to do so by regulating the technological practices specifically, or should those laws be more broadly framed? So when I put in my title, asking all the wrong questions, it's really about the fact that a lot of the time, the question is framed as how do we regulate artificial intelligence? Or what is the right ethical framework for artificial intelligence, rather than going through that series of questions. But let me explain further. Hold on, there we go. I'm going to start with some examples, not about artificial intelligence, but that highlight the kind of problem I'm talking about. In other words, the challenge when governments and other organizations talk about we need to regulate something or we need laws for something. So go back quite a bit in time to when there were digital tapes. And digital tapes created a significant challenge for content industry, so music in particular. The music industry said, how are we going to sell music, right, in stores if anybody can buy a copy of that music and copy it onto a digital tape, which makes a perfect copy, unlike the previous analog tapes. And then they can sell that to, give it away or sell it to their friends. And no one's going to come into the store to buy the music each time, because now we have a technology that can make perfect copies. So there was a new technique, a new technology, digital tapes, a new affordance from that technology, in this case, the ability to make perfect copies. And then the question that was asked, how do we regulate digital tapes? And around the world, special laws were passed about digital tapes, right? So there was a law that said, in Australia, for example, there was a special tax put on digital tapes. So when you bought a blank digital tapes, you paid the idea was you were going to pay this additional tax, and that money would be used to compensate the music industry, right? And Australia was not the only country to develop regulation that very specifically referred to digital tapes. Now, what happened is that not very many people now use digital tapes. So all of those laws have no application. If there's a special tax on digital tapes, maybe, but no one's paying it because no one's buying them. But we still have the underlying problem. We still have the ability to make perfect copies, and that is still a challenge for copyright law, right? It's just that the solution we came up with, that first knee-jerk solution, didn't help anything. Let me give another example, this one a little bit more recent, but not much. Nanomaterials. So nanomaterials are, I should say, very small particle size, right? Where you have something, typically between 1 and 100 nanometers, at least in one dimension. And then by creating a small particle size, you can actually create a different properties from the same chemical. So you can have something like silver, which has certain properties normally, but when you create a nano version of it, it has quite different properties that you can use for different things. And you can get nanomaterials in everything from sunscreen to clothing, with effects like, how well you need to iron your clothes and so forth. It has a whole range of different effects. It makes things behave differently. And when this first came out, again, you had this idea of we need to regulate nanotechnology, or we need to regulate nanomaterials. And some jurisdictions did. There were, special laws passed in Europe, for example, which had a different sort of regulatory process where nanomaterials were involved compared to the broader chemical regulation. But actually, as we've worked out, we didn't really need that. It wasn't that nanomaterials needed specific regulation that regulated nanomaterials per se. We just needed to fix the existing regulation so that it didn't not regulate nanomaterials. So what do I mean by that? So chemical regulation has generally speaking, will have different regulatory requirements where your chemical is new versus when you're doing something that's already been done before. And obviously the threshold for, you get more regulatory attention where you're making a new chemical. But the problem was, if you manufactured nano silver, at the time, that was said, well, we've already got silver. So you'd get the very light touch regulation rather than the really high level of testing regulation. What was needed was not, let's have a special law for nanomaterials. What was needed was just tweaking the existing chemical regulation to say that particle size was a property that made a chemical new. In other words, if you changed the particle size, that would make it a new chemical that needed to go through the higher level of regulation. Now, why does that matter? Why is that approach different to a special law for nanomaterials? Because nanomaterials have evolved. The way that nanomaterials used to be defined is no longer the way they're currently defined. So if you create a law for a particular technological practice, that law almost certainly becomes obsolete. Now, there are exceptions to this. Sometimes you do want to regulate a particular technology. So my example of that is human reproductive cloning, right? There are rules all around the world in many different countries that prohibit human reproductive cloning, that say you cannot do this particular technological practice, right? And why does that matter? It matters because it is the technology that we want to prohibit. In other words, it's not the end state or outcome, but rather the means used to produce that outcome. If we simply prohibited the outcome, that is human clones, you're actually prohibiting twins. Identical twins are prohibited because they're human clones. So we're happy with the outcome, but what we're uncomfortable with is the actual technological means of getting there. So in that context, a prohibition on the actual technology makes sense. But in particular, what governments and lawyers need to do is move from a habit. And the habit is, let's look at the problem, let's name it, let's define it, and then let's regulate it. Because if you do that, you get special laws for digital tapes, special laws for nanotechnology, when that isn't always the best way to achieve the goals that you're looking for law to achieve. There are a whole variety of things that can go wrong. Well, that can go wrong with sui generis rules. That is, rules that only apply in a very particular context. There's a tendency to want to create them, right? That we want to treat new entities, new activities, new relationships that relate to new technologies as somehow different. And we say we want to regulate AI. We want to do something about this difference, about the technology. But we need to bear in mind the costs as well as the advantages of responding in that way in terms of how we formulate our regulation. And often it's better to link to a broader general category rather than to regulate at that specific technological level. And even if we do want to introduce new rules that will deal with a specific kind of problem, we nevertheless need to think about how we can adopt a relatively technology neutral approach. At the same time, we have to be able to think about law in a way that goes beyond the specific. So Oliver Wendell Holmes, who was a famous American jurist, once mocked a Vermont justice of the peace because allegedly, and it's a bit of an apocryphal story, the justice of the peace had said in relation to a dispute involving churns, there is no law of churns, so I can't decide the dispute. In other words, unless there's a law specifically about this object, I can't decide a dispute between two people about, one person smashing another person's churn or a contract to buy or sell a churn or anything else. And that's clearly wrong. Most law operates at a very general level, particularly in the areas like tort, contract law, and consumer protection. They're able to operate across technologies, across different kinds of objects. So it was interesting for me that I went on a trip to Germany. And Germany has a cybersecurity act, which deals with issues around critical infrastructure and cybersecurity risk in relation thereto. And I went along and they had this map, and the map had been produced by Deloitte. And the map showed which countries have cyber law, which countries protect against cybersecurity threats. And Germany was on there because Germany had a cybersecurity act that dealt with the cyber risks around critical infrastructure. And Australia was blank. They said Australia doesn't have such laws, right? Now, the reason they said that is that there was at the time no Australian law that had the word cyber in its title or in the provisions. We have, and we had, a Critical Infrastructure Act, right? We had legislation protecting the security of critical infrastructure, but it dealt with security at a general level, right? It dealt with security, whether that security was a physical threat or a cyber threat. But because it dealt with it at a general level and didn't mention the word cyber, it wasn't included on the map. And Australia was considered to be invisible, which of course doesn't make any sense, because our legislation and Germany's legislation did very similar things. And in a lot of scenarios, you'd have exactly the same answer from the German Act and the Australian Act. The only difference was the German Act was cyber specific and only dealt with cybersecurity threats, whereas the Australian Act was broad and dealt with cyber threats in amongst all of the other potential security threats that could occur. So we have to be able to think about, so there's two sides of the equation, if you like. We have to be able to think about law reform and frame that beyond technological specifics, but we also have to understand law and what law does beyond technological specifics. So if you like, the fact that we don't have a law called the AI law or AI regulation, like Europe's proposing, doesn't mean that we don't have laws that deal with artificial intelligence. So that's all at a very high level. I want to get down to the specifics. What is artificial intelligence? And what I've put up on this slide is just a small selection of the many definitions that are out there as to what artificial intelligence is. And insofar as artificial intelligence is a new discipline within computer science, within engineering, within science, within mathematics, within data science, and so forth, to the extent it's a new discipline, it's fine for them to still be arguing over exactly what that discipline is going to do. So what are the objectives and so forth? That is absolutely okay. But if you're thinking about artificial intelligence as something to be regulated, the diversity of definitions is itself a problem, because what is your definition for the purposes of whatever regulation you're going to introduce? And does that definition align with the concern that motivated the regulation in the first place? So let's look at some of these. The OECD defines an AI system as a machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments, independent of the level of autonomy with which it operates. So this is interesting, right? Is that what we want to regulate? Anyone who builds a system that can operate with a human-defined objective in order to, for example, make a prediction, right? Because if that's part of the regulatory object, then a lot of the programs my son writes just for fun would be regulated, even though, right, potentially it only influences a virtual environment, being what's happening inside his computer, even though you know, it doesn't really affect anybody else. It's just a learning project or something similar. Nevertheless, it could fit this definition. It's an incredibly broad definition. It includes things well beyond the sort of classic machine learning, highly sophisticated techniques. In many ways, it would include quite a lot of just ordinary computer programming. So that's one way of defining it. Another, which is a variation on a theme, this is the one used in the proposed EU regulation. So software that is developed with one or more techniques and approaches listed in an annex. Now, whatever that list is going to contain now, I can promise you that in 1 year, those techniques will look obsolete. In other words, whatever that list includes, it will be particular ways of doing things now. It will not include techniques that are still in development that we don't know about yet. There's no way to include the unknown future of a technology in a list like that. So the list will, you know, be its own form of obsolescence. But let's move on. We have that again idea of a given set of human-defined objectives, but we're going even broader now. It's not only about predictions, recommendations, and decisions, right? It's just generate outputs such as content, right? So you think about how broad that is, and that is now the object of European regulation. But we could go for completely different kinds of approaches, right? Perhaps we only want to regulate things that require intelligence, right? Or activities devoted to making machines intelligent, where we have some definition of intelligence. That would be a very different kind of definition, right? Now, the concern there is intelligence is a bit of a positive, right? We use the word intelligence to describe something good, right? We praise our children for their intelligence, for example. So, you know, what you are doing, if you like, is only regulating systems that are intelligent and not systems that are stupid. And the problem, of course, there is that a lot of systems that cause the real problems, you'd classify on the stupid rather than the intelligent. So let me give you an example. I was at an event that the Australian government hosted a year ago that they called Tectonic. Well, maybe it was more than a year ago. Must have been more than a year ago. A year ago, there were no events. It was COVID. So maybe 2 years ago. They hosted an event called Tectonic, which was meant to be this sort of AI, government, industry, academia, big event, right? And they launched at that event AI ethics principles, and I'll come back to those in a minute. And the principles sounded fantastic, right? They said, you know, all the good things that you want principles to say. At the same time as that event was running, the Australian government was using a software program that issued debt letters to citizens. Now, what this was called robo-debt. Many of you may have heard of it, but for those who haven't, what this did is it tried to automatically deduce which people had been overpaid welfare and therefore owed the government money. But it did it according to a mistaken formula, right? What it did was it said, what's your annual income? And we can get that number from the tax office. Let's divide that by the number of fortnights in a year, and we'll call that your fortnightly income. And then let's compare that to the welfare you received versus the welfare you would have been entitled to receive with that income. And then we're going to automatically send a debt letter to you if we think you owe the government money based on that formula. Now, the reason that's wrong is that if your income is unstable, so that you earn more in some months than in other months, or some fortnights and other fortnights, that formula is going to show that you owe the government money when you don't owe the government money. And that's, I think they worked out about 20% of people, that's the nature of their income. It's not stable, it's not static, it's not the same every fortnight. So people were getting issued debt letters that they didn't owe, right? So let's look at this definition from Nielsen, right? That activity devoted to making machines intelligent, where intelligence is that quality that enables an entity to function appropriately and with foresight in its environment. Well, robo-debt doesn't operate appropriately. So it would fall outside the regulation if we used a definition like that. Right? And in fact, when I raised robo-debt at the Tectonic event that the Australian government hosted, I was told that's not artificial intelligence. So I was asking, we have these ethics principles. How can you have those ethics principles at the same time as they were at the time still doing the robo-debt program? And the answer was simply, it's outside of scope. It's not artificial intelligence. So that's why I'm concerned about framing what we want to do in terms of ethics or regulation that is only about something called artificial intelligence, however that might be defined. And I've yet to see a good definition. So I said I'd tell you what the ethics principles were. The original one that came from Data 61's paper, and there was a whole range of them, but here's an example. An AI system must generate benefits for people that are greater than the costs. When that got turned around by the Australian government and the government issued its version, that became human, social, and environmental well-being. So throughout their life cycle, AI systems should benefit individuals, society, and the environment. Now, these all look great, right? Who could possibly object to this? But the reality is, all it's really doing is taking what might be seen as a very general, high-level ethical principle, like make sure the benefits outweigh the costs, or make sure you benefit individual, society, and the environment, and then adding the word AI systems in there. It's not a very deep exercise in applied ethics. I've seen much better ones where you really engage with specific ethical challenges in a context where you need to do things differently in that context because it raises a new ethical issue. This does not do that. And I don't have a problem with the idea of applied ethics, but I do have a problem with the idea of what I might call hypocrisy in applied ethics. So this would be fine. And the government saying AI systems should benefit, all these things would be fine if, for example, the government was also willing to say, our government will always act in ways that benefit the environment. But it doesn't. The Australian government, is well known for, promoting mining projects and other things that do not benefit the environment. So either you say, and let's not get into that particular policy, but either you say it's important to benefit the environment and that should be a strategic priority, in which case you say it for everything, or you don't. There's no particular reason that I can think of why the only time you need to worry about the environment is when an AI systems is involved. So if this is just saying ethics matters and ethics also matters for AI, then that's fine. But that's not what tends to go on in these kinds of AI ethics principles. What tends to go on is that we only talk about ethics for AI, that governments that have no ethical framework at all for day-to-day operations suddenly think they need one for AI. And then they write them in such a way that looks like the only time we need to worry about these high-level principles is AI. So in other words, if we took out the red here and said government should, or industry should, or any other entity, then I get it. But saying only AI systems should, I think is a little bit of a cheat. Now, many of you might be thinking, but AI raises some important issues. There are risks and harms associated with AI that we really do need to focus on. And that is absolutely right. I've sketched out some here. Everything from, automated vehicles and the different kinds of risks to safety on roads, challenges of bias and fairness that get discussed a lot. The computer says no problem of, you can't reason with a machine, human dignity. And in the context of automation, just being treated as an output of a system rather than having a judgment made about your situation by a human that respects you as a person. Explainability, and I heard that that there's more on that in the rest of this symposium. Vulnerable populations and the way that they might be affected by artificial intelligence. Robodebt, in fact, is an example of that, even though it's not really artificial intelligence, right? Is that it was targeting people on welfare. It was targeting vulnerable populations. And that's often what happens with AI systems, is that the automation very rarely makes automated decisions about those who have power. Autonomous weapons is another really important international issue. Care robots and the role that robots might play in aged care in particular. Social media, concerns we have about privacy and surveillance. Robots and how they might interact with people. I mean, there's a whole range of different questions that we might want to ask about AI and that we want the law to grapple with. So that's all true. But I still want to go back and ask, are our concerns really about AI in the way our concerns about human cloning were really about something technological, right? In other words, the concern was the particular technological means of producing something. Or are these just examples of what might be a broader problem? So let me hone in here on the bias fairness example. If we're thinking about, it doesn't really matter that AI is involved, or is our concern the particular kinds of historic bias can seep into future decision-making through the ways in which we analyze data and use that in our predictive models? Because the concern, I think, is less about the automation, less about the fact that you're using particular techniques, call them machine learning, call them anything you like, and more about the way in which we're using historic data. In other words, if you think about the kinds of systems that have been challenged for fairness, in my view, you would have exactly the same problem if instead of using machine learning or some other AI technique, instead you used classic stochastic techniques, statistical techniques. If instead you had hundreds of people in a room performing calculations really slowly to work out where the correlations were. if those correlations are being used in future decision making, right, because you have a particular model that you're using of the world and you want to, you know, treat people in particular ways according to how you predict they'll act, you can do that using machine learning and AI, but you can also do it in really old-fashioned ways. So an example of this is the parole system in the US state of Virginia, which it had a data-driven model of when it would give parole to particular offenders. And they had worked out on the basis of that predictive model that people who are pedophiles, who commit sex crimes against young children, people who commit those crimes against young boys are more likely to reoffend than people who commit those crimes against young girls. That was apparently a statistical correlation that they found in the data. This is before machine learning. This was very old, right? And so what did they do? They decided that they were going to adjust the points, because they had a kind of a point system, very manual, adjust the points of offenders so that essentially if you had offended against a young boy, you'd spend longer in jail, you'd get parole later, compared to if you'd offended against a young girl. Now that created, in my view anyway, all sorts of bias and fairness problems, right? It created a bias for the population. Because if you think about it, right, for a second, what you're doing is you're skewing the risk for young boys and young girls in the population away from what it would be in its natural state by keeping the pedophiles away from the boys for longer than you keep the pedophiles away from the girls, right? So that created, if you like, a social bias where girls were at greater relative risk to boys because of a parole policy in that state. There are other problems with it too. It sends a poor message to society because it seems to indicate the suggestion that offending against a boy is somehow worse than offending against a girl, right? Which sends a biased message, if you like, to the broader community about what matters and what a crime is and what the worst crimes are. So there's a whole range of problems because of the way data is used, that are fairness or bias problems, if you like, without any AI being involved at all. And that's just one example. There's lots of ways in which one can use statistical patterns in decision making in ways that involve bias, right? So really, what do we need to be asking ourselves is not so much, was the process automated? Did we use the techniques in Annex 1 of the EU regulation or anything else? But how do we make decision making? How do we do decision making well in ways that are fair, given the historical biases that will inevitably be in the data sets that we often use in our modeling? That to me is the right question. And that's a broader problem than only artificial intelligence. So let me tackle another example now. This is the challenge of transparency, explainability, and accountability. So I'm just going to do a little brief introduction to these concepts, and a lot of you will know a lot of this, but just to make sure we're all talking about the same thing. So transparency is really about how much someone outside knows. So if you're looking at a system, it might be, you know, a machine learning system. It might be, where did the data come from? Was it altered or cleaned? How accurate is it? What algorithms were used? What assumptions were made, and so forth, and telling people what you're doing, right? So you're being transparent about the process. Opaqueness takes things from the other side. So it looks at things, if you like, from the perspective of the public who want to understand a system. And even systems that are transparent can be opaque because, and this is a great article by Jenna Burrell on this, there's different kinds of opaqueness. Something might be opaque because people deliberately don't tell you about it, right? So maybe they can't tell you the algorithm because it's a trade secret. Or maybe they're a law enforcement agency and they're concerned about operational secrecy, so they don't tell anybody how they do predictive policing or something else, right? So that's the first kind. The second kind relates to the audience's technological literacy. So maybe I tell you everything, but you don't know that much about data. You don't know that much about machine learning. I can describe the algorithm to you and your eyes glaze over. So even though I'm telling you about my process, you just don't understand it, right? So to you, it's opaque. Well, hold on. There we go. Okay, the slide's working now. Okay, so to you, it's opaque. The third example is complexity. So this is a particular thing in areas like certain kinds of machine learning where even if I explain it to you, even if you're an expert, it's very hard to understand or predict how that algorithm is going to behave because it's so complex that it's beyond human reasoning. So if you think about something like a random forest algorithm, right, where you're generating, you know, hundreds and thousands of different probability trees based on the data set that you're using for training, and then you get those trees to vote on an outcome for a particular individual, right? That, yes, you can describe that. Maybe, you know, at that level you understand it, but you can't really understand the behavior of the system because there's too many trees to absorb and understand what each tree is doing and how that might affect the overall vote and so forth. So it's just too complicated. So what can we do? We can think about translucency. So it's not so much about telling people everything, but telling them what they might be most interested in. So perhaps you don't tell them everything, but you can show, for example, that the false positive rates for a particular algorithm are the same for different racial groups. And that might be one way of proving something like fairness, at least a kind of fairness. And there's different kinds, but you know, you can demonstrate particular features of a system without telling people everything about it. And sometimes that's actually more useful than telling people everything about it, right? It's the thing that they want to know about it or the thing they want to understand. Another example of how you can be translucent is through evaluation. So let's suppose I'm in the market to buy an automated vehicle. I don't necessarily want to know everything about that automated vehicle, right? I don't really care how the algorithm works. And I probably wouldn't understand it even if someone took the time to explain it to me. What I care about is that that car is not going to crash, right? And what do I want to know? I don't want to look at its source code. I don't necessarily want a long explanation as to how it does its learning process. What I want is I want data on an evaluation. Has it been tested on roads? How many times did it crash? Were the test dummies inside the car injured in the crash and so forth? That's all I want to know. And it's the same thing to a large extent with something like facial recognition, right? I don't really want to know how facial recognition works. I don't care whether it's looking at the sides of my mouth or my nose shape or my forehead width or anything else. That doesn't help me understand anything. What I really want to know is, does it perform, right? Does the facial recognition work, accurately identify the individual whose face it is in some high proportion of cases? And more than that, does it do so for different racial groups? Does it do so for men and women? Does it do so for the population on which it's going to be used, right? That's my question, not tell me the algorithm. So evaluation can be one way of getting the kind of information people want. But what kind of information do people want? They want an explanation, right? So this is where explainability comes in. People don't necessarily want a full description of everything. They want to understand, for example, why a decision's being made. And if someone says, we've decided to replace all of the vehicles of the government with automated vehicles, and I say why, I don't want an explanation of how those vehicles work and what algorithm they're using. I want the answer because we've tested them and they're more safe, right? So what you want in an explanation is going to vary by context. And what you ultimately want is something like accountability, right? So you want to make sure that decision makers are accountable for those decisions in accordance with the normal chains of accountability for which, on which we run our entire society, right? And there's different structures of government. But in Australia, ministers, are responsible to, you have the sort of chain, right? So ministers are responsible to, to the whole population for their whole portfolio and so forth, right? They're responsible to Parliament for their whole portfolio, right? So we have this sense in which someone is accountable at the top, and that will depend on the context, the CEO of a company, the minister of a government, right? And then there's accountabilities all the way down. So people at the bottom end of some sort of process might be accountable to their boss, who's accountable up a kind of chain. And where those chains end, again, depends on context, right? So government accountability chains are going to look quite different to what might exist in the private sector, which will look different again to what might exist in a national security agency, where accountability might be through to a independent oversight body. Like in Australia, we have the IGIS, who oversees all of the national security agencies. So accountability is also contextual in terms of who has to be accountable to what, for what, in what circumstances, to whom. So transparency is necessary to some extent, but it's certainly not sufficient for accountability. And explainability also intersects with accountability, but again is also going to be deeply contextual because it's all about where the responsibility chains lie. Therefore, we need to think about this in much more complex and rich detail than saying AI should be transparent. So you'll see AI ethical principles that we'll talk about. AI has to be transparent. AI has to be explainable. But I think that misses a lot of the nuance of what I would call context. Explainable to whom, for what purposes, in what context, and why, right? And I think that's a lot more important than that's sort of the real question, if you like, rather than what does AI need to be in some kind of abstract whole. So, you know, we can think about transparency to whom. So most government decisions don't need to be transparent to the whole public. I have no right to know why somebody else isn't eligible for a welfare benefit. I have no right to know why police choose one site for random breath testing rather than another site for random breath testing. I do have a right to know and get reasons for decision for why government makes a decision about my benefits, right? So I have my right to know is deeply contextual. When government has to give reasons to me depends on the context. So in other words, what really matters here is context. Some decisions do not need to be explained to anybody, right? If I came up with a dating algorithm that recommended who people could date, right, or go out with, I could say this is a black box dating algorithm, and there's no reason why anyone is going to make me explain that to anybody. And if people want to use a black box dating algorithm, then good luck to them, right? There's no reason to say because it's AI, it has to be transparent, or because it's AI, it has to be explainable. I can make that algorithm any way I want, and people can decide whether or not they want to use it on that basis. On the other hand, some decisions need to be explained to everybody. So a judicial decision needs to be explained to everybody, right? We expect our judges to write their judgments and explain the reasons for decision to anybody who's interested in the outcome of that case, not only the parties to the litigation. Whereas other kinds of decisions, like government decisions, might only need to be explained to those affected by the decisions. So it's all context dependent. So we can think about when we need to explain different kinds of decisions, right? When private decision makers need to explain their decisions in very particular contexts, they do. When governments need to explain their decisions, right? And often only to the person affected. Sometimes they need to explain things to everybody. But often not. And judges who do need to give reasons that need to be, that need to, explain the reasons behind their decision to everybody at all. So we may or may not like this, but the law already has rules about who needs to explain what to whom. So administrative law is its own battleground, and I won't go there now, and law reform may be needed, and again, I won't go there now, but it does state that administrative decision makers need to make decisions to those affected. So the question is not, do AI decisions need to be explained? Because what we should instead look at is, in what context do AI decisions need to be explained? And the decisions do not necessarily need to be explained because they involve AI. They need to be explained because they're a particular kind of decision. So if we think about the dimensions of decisions, what sector is it made in? What is the factual and legal context of the decision? What is the context of evaluation of that decision? So is it being challenged by someone with standing to do so and so forth? We can work out, if we have all of that information, in what kind of explanation needs to be given to whom, right? Adding in that there's automation involved or AI involved should very rarely make a difference to the answer we would give based on the remainder of that context. So that's why I have a problem, at least, with things like Article 22 of the GDPR. What this does is state that data subjects have a right not to be subject to decisions where those decisions are based solely on automated processing, and further, that they can get meaningful information about the logic involved as well as the significance, etc. So this creates and I'm not going to go through the whole law because it's a bit complicated, but where a decision is based solely on automated processing, there is in particular, among other things, a right to meaningful information about the logic involved, right? So what this says is that it's the automation dimension that triggers the need to explain decisions in particular ways. And I think that's a problem. An automation scale doesn't seem very helpful here. In practice, it'll basically very rarely apply. So my guess is what European companies will do in response to this is put some kind of human in the loop and say, oh, a human's looked at it, so it's not solely on automated processing. It was just a recommendation that went to the human and the human just followed the recommendation or something like that. Because at the end of the day, it's very easy to get around these kinds of technology-based definitions. You just fall outside their scope. But the main point is I don't think this is the right way to think about the problem. In other words, it's an excellent answer, give reasons for decision, to the wrong question, right? How are we going to deal with decisions made through automated processing only? So I would argue that when we're thinking about transparency or explainability or accountability in decision making, we don't necessarily want it just because algorithms are involved, just because particular AI techniques are being used, or just because it's based on automated processing, right? However those terms might be defined, which is its own problem. Rather, I'd flip it and say the fact that a decision is automated based on AI, etc., is not an excuse for failing to explain a decision where such an explanation is otherwise required. So if we go back to the Robodebt example, the fact that the system said you owe money is not an answer. If government has an obligation to give an individual explanation to individuals affected by government decision making, it has to do the same job as it would have done in the absence of that automated system. Right? It has the same standard it has to meet. So my argument, again, is broadly that the type of transparency required or the type of explanation given should be similar, whether the decision is based solely on automated processing, relies on inferences drawn from automated processing, is done by 1,000 humans in a room working really slowly through data-driven statistical reasoning, or is done by a traditional human decision maker. And the attempts to draw distinctions among these based on definitional nuance, as we've seen in the various attempts to define AI, is ultimately a flawed approach. But we're not done, because we still have to deal with the technical challenge here, because it is hard to generate decisions from certain kinds of machine learning techniques. There are technical challenges in getting a neural network to explain why it reached a particular output. Right? We're clearly, when we ask that, we don't want a neuron by neuron explanation, right? If I gave you this picture and put weights on all the little neurons, that's not going to help for the reasons Burrell explained, which is that it's so complex, no human's going to understand what that means for them. So we don't put human decision makers in functional MRI machines to see which parts of their brain light up when they make decisions. And even if we did, that wouldn't be a useful explanation of their decision. And similarly, I don't think we should do that for neural networks. So different kinds of decisions, so we have to think about, what kinds of decisions can we use neural networks for if they can't give a useful explanation? So we have to think about what kind of explanation we need. And as I said, that the kind of explanation we need is going to be context specific. So one kind of explanation that's often given is a counterfactual, right? So judges in a judicial decision will often give a counterfactual, like, had the facts been X, it would have been a different answer. And that's really helpful in understanding the rationale behind the decision, because it tells us which facts were material to the judge's decision. Counterfactuals can also work in other kinds of contexts. If you had turned up for work on time, you would not have been fired, that kind of thing. So it's one way in. Administrative decisions have to meet statutory criteria for reasons for decision. They have to state the evidence that was used in reaching a particular decision. And certain kinds of AI can do that really well. So expert systems can absolutely nail that kind of an explanation, which sets out all of the relevant facts that were present in a particular decision. Sometimes the only thing you need to prove, and again, this is coming back to context, is that a decision was not made for a particular reason. So I might, if I'm a private organization, I can price goods pretty much however I want, right? No one can ask me to explain why this costs $3 instead of $3.50. But if, for example, I charge people different prices based on their sex or their race, then I'm going to get into trouble. So I don't necessarily need to give a full explanation for my pricing, but I do need to be able to demonstrate that the pricing is not, say, racially biased and so forth. So we could generate that kind of an explanation, and even a neural network could generate that, right? So it could generate a proof, if you like, that in all the different circumstances of pricing, race made no difference to the way the outputs were generated. So once we understand the context, we can ask what kind of transparency is required or what kind of explanation must be given. And then we can ask, is it possible to automate that decision in a way that preserves that? Now, we can build on that. We can have research in explainable AI that will improve how explanations are generated and prove how explanations are measured and evaluated, right? We can do counterfactuals, where we can measure inputs and outputs in particular scenarios to generate reasons and explanations of what the variables were that triggered a particular decision. We probably cannot generate reasons that are going to be good enough for a judicial decision. I can't see any kind of automated system generating the kind of reasons that are required to meet that standard of explanation. But my broad point is that using automation cannot be an excuse for not providing the kinds of reasons that the circumstances require in the context in which they're required. And that might mean that sometimes you cannot use certain kinds of AI techniques to make certain kinds of decisions. And the reason you can't do so is that on current technology, that particular technique cannot generate the kind of reasons for decision that is required for the particular context in which the decision is being made. In other words, the AI doesn't stack up, right? It doesn't meet the needs of the situation. So we need to be prepared in some contexts to say, we can't use this particular AI technique to automate this particular kind of decision. But it's not just about requiring transparency only when AI is present. So in other words, if you like, you sort of say first what kind of explanation is required in the context, and only then is there a way of automating it and providing an explanation of the kind required. So if we're thinking about opaqueness in machine learning, we can think about it in this order. Are we happy with existing law on when reasons are required? Leave aside AI-specific regulation. Are we happy with administrative law? Are we happy with the fact, that there are very few circumstances when private companies need to explain their decisions and so forth? So are we happy with existing law? And if not, let's fix it. But let's not just fix it for AI. Let's fix it for everything. Otherwise, we need to ensure that AI is not an excuse for failure to give reasons where they're otherwise required of the quality required. So we need to align the affordance and limitations of particular techniques with what's required for particular decisions. Yes, we can extend that out. We can do more research in explainable artificial intelligence. And we can also create technical standards that can guide on how to generate reasons and how to test the reasons generated for accuracy and reliability. And ethics can also be used to take us beyond law. Maybe we want to be better than the law. Maybe a particular organization goes, we want to act ethically even when we don't otherwise have to give reasons. We want to explain things to our customers because we want to be a good organization that's open with our customers and transparent and wonderful. But don't just do it for AI. Do it because you want to explain things broadly and be transparent in that broader frame. Okay, so what is the right question? I said I'd start with all the wrong ones, but here's an attempt at the right ones. Given our existing legal and regulatory framework in India, in Australia, wherever we are, what changes are required to respond to the unique considerations raised by new activities, entities, and relationships? So, as I've said, my answer is not going to be necessarily regulate the technology, but we can ask this question for AI. What laws need to change? And there will be laws that need to change. Here's my, short list of the kinds of areas that might need law reform. All of these areas of law affect what's permitted, encouraged, discouraged, or prohibited in the context of artificial intelligence. But they're imperfect. Just to give one example, discrimination law was really designed for human decision makers who might be racists or sexists or something else, right? It's broadly designed to catch people with a deliberate animus or poor opinion of a group, and then basically to, you know, also catch people who try to get around that by using a proxy. So people who say, oh, I don't not hire women, I just don't hire short people or something, and then women are shorter than men, and so they don't hire women, right? So it's to avoid those kinds of situations. But it doesn't necessarily work well where the reason for discrimination is actually driven by historic data. And it's simply, if you like, perpetuating that data into the future without doing an evaluation of what the differential impact on different groups of that process might be. Discrimination law doesn't go that far, and maybe it should, right? But my argument is, if it should, it shouldn't just be about the use of AI. It should cover all of the other techniques I spoke about before. So the ordinary statistical techniques that can be used to cause exactly the same kinds of problems. And it's similar on privacy law. We don't need to think about the privacy of some category called AI data or data in AI. We need to think about data privacy, and certainly in Australia, we need to fix our privacy law, but we shouldn't only do so in a sort of AI frame. We need to think about it far more broadly. And of course, the same thing is true for a lot of soft law. So I'm involved in standards, both with ISO through Standards Australia, as well as with IEEE. And standards are most useful where they fit into a broader agenda. So one of the standards that I'm working on with ISO, this is in SC42, the artificial intelligence standards, is an artificial intelligence management system. But the idea of that is exactly that you have a broader management system that you're using to, you know, manage your organization, and artificial intelligence keys into that to ensure that the broader framework applies appropriately in a context where your organization is using artificial intelligence. So it's expanding on a management system rather than saying only have one for AI. And similarly, other standards that deal with governance, that deal with risk, that deal with quality control, standards work best where they draw on the fact that you need quality control for everything, for all of your systems, if you like, not only those that meet a technical definition of artificial intelligence, but that maybe when you are doing quality control for artificial intelligence, there are additional factors you need to consider that wouldn't be applicable in other kinds of systems, right? So you adapt the broad principles into the particular context. Standards are also more useful when they focus in a specific way on how those general propositions can be achieved. So we should have standards that help organizations measure and evaluate for bias. We can have standards on how to generate explanations from artificial intelligence, and then how to test those explanations. All of that, I think, is a really good idea. So coming to my conclusion, targeted law and regulation is not saying, you know, we don't have an AI law doesn't mean that we're weak on AI or something like that. And having an AI law doesn't mean you're better at dealing with AI. It's not about whether you use the word in your laws and regulations. It's about how do we ensure law reform in this area in order to adapt to all of the new circumstances AI is raising, but in a way that will also evolve as socio-technical systems continue to evolve. So we have to be adaptable, and the best way to be adaptable is often not to mention immediate technological practices. There is a place for technological specificity, but it's quite narrow compared to starting out with the wrong question. In other words, we don't want to ask how do we regulate AI, but we may need in some narrow and specific areas, laws that do deal specifically with particular techniques where appropriate. We need to think, however, about law reform with a broad lens. We need to think about the role of soft law, such as technical standards, and where they can offer technologically specific advice on how within broader concepts like governance and like quality. And we need to ensure that our applied ethics, our AI ethics, isn't just the only ethics we ever do, or pretending that ethics only matters for machines. We rather need to frame that within a broader ethical approach. Thank you.
Thank you, Lyria, for giving such an outstanding talk. I really enjoyed that. So let me first see whether there are some questions from the audience. So there is a question from Anup VS. Anup is asking, I have a question on IP law that is generally with respect to the models produced using so-called private data. Specifically, I am referring to the case where someone uses private data to derive a model. Can the owner of the data claim ownership of the model, even though the model may represent a domain far more generic than the privately owned data?
Okay, my answer to that is I would disagree with the premise of the question, at least under Australian law. So I don't know Indian law on this issue, but under Australian law, there is no ownership of data. So nobody owns data. Data is simply not an object of property rights. And our High Court has said so in a number of different contexts. So because there's no ownership of data, you can have control of data. You know, I own my computer and my computer might have data on its drive, right? And that might mean in practice, I have a certain ability to manipulate that data or use that data, but I don't have ownership rights over that data. So at least in Australian law, the premise of the question doesn't hold.
So does it mean also that I don't have control over my or the rights over my private data? And so, for example, suppose the intellectual property that I produce, right? That is also data, right? For example, a piece of writing or a piece of algorithm or anything like that.
So your intellectual property rights will depend on the kind of IP you're claiming. So if, for example, you write a letter all about yourself, right, describing all of the things about you, you will have, there will be several kinds of rights you have in that, right? So one is the copyright. Yes, that you write a letter, right. You've expressed things in a particular way, and you have copyright in it. That doesn't give you any kind of ownership of the facts, right? So it gives you ownership of the way in which you express a particular thing, right? So, you know, you don't have ownership in the raw facts themselves. You do have some rights in information about you, though. So, for example, in Australia, we have the Privacy Act, and that means that organisations have to do particular things when they process my data. First of all, they have limits on the context in which they can collect that data. They have to collect it for a purpose. They have to tell me something about it, like a privacy policy, about what they're processing, you know, how they process that data. There are exceptions to all of this. I'm being very broad brush, but that protects my information about me and says organizations can't do whatever they want with information about me. They have to obey the rules in the Privacy Act about the collection, use, disclosure of information about me. But that doesn't mean I own information about me. It just means that I have the rights given to me in the Privacy Act. It's not the same thing as ownership.
Okay, thanks for the clarification, Lyria. So the next question is from Rinkaj Goel. So Rinkaj is asking, what if the reason of the evolution of a technology is its unexplainability of the underlying reason only, like AI systems are becoming smarter because of deep learning, where the process of identifying patterns cannot be explained except that it mimics the human way of correlating things, homophily.
Okay, so there's lots of contexts in which it's great to use those systems, right? I can think of a whole variety of applications that might be useful. So a system that, for example, can recognize faces like humans can, or a system that can, you know, describe a photo like humans can, right? So there's lots of really good uses of that technology in research. My main point is that using that technology, which can't create an explanation, in particular contexts would not be appropriate. So I would not necessarily want that system being used, for example, to replace judges. So in other words, I don't think, if, you know, even though it can, you know, do things like humans or learn to do things like humans, when I go to court, if I'm charged with a criminal offence or whatever it might be, or I'm, you know, arguing with my neighbour over where the fence is going to go, whatever the legal dispute might be, I want a human judge who can exercise their own judgment. I don't want a simulation of that human judge who can't actually tell me why they made the decision other than I've analysed human judges and this is the kind of thing they do. That's not good enough for what we want our courts to do. So what we can think of from that kind of system, it can't generate an explanation. It's very useful, but it's not going to be useful in certain kinds of decision-making processes where what we want is not only an output, but an explanation.
Yeah, I agree. And for example, I mean, for like the simple image recognition of things are fine. But if it's, for example, used by the law enforcement for face recognition, and they using that, they using a deep learning system, they recognize somebody as a criminal declared, And then of course that can be challenged, right? Because if I am being, for example, flagged as a criminal by a face recognition algorithm using deep learning, then of course I have the right to challenge that, right? And saying that, see, there is no explanation given to that why I am being flagged as a criminal.
Well, I think that's less about explanation than it is about other things. So it depends on what the system's doing. If the system is saying someone with your face, if you like, that we've identified as having the same face as you, broke into the bank yesterday, and so we now want to question you around that crime. You can have all sorts of concerns about that. So one concern might be maybe this is not very good at identifying faces of people from Indian heritage, possibly, right? So maybe it has a really high error rate in that context because it was trained on mostly, white American faces or something like that. And if that's the case, then your concern might be, I'm going to be a suspect in lots of situations where I did not commit crimes because of my ethnicity. On the same point, I should say for women in the case of gender, because a lot of these systems don't work very well on women's faces compared to men's faces. So we can have a concern about the system in that sort of sense. We might have a concern about systems that are now being deployed that detect criminality as a kind of new form of, they used to measure skulls and say we can tell who's a criminal. So maybe they'll just look at your face and go, you look like a criminal. Look at that expression you've got. That's a very criminal expression. And we can be concerned about that because it's scientific bullshit, right? It doesn't really work, and it's not a very good idea, even if it did. It would just be contrary to human rights in so many different ways. So I think that in that context, we could object. But if really all the police are doing is saying we've got a system, we've evaluated and it works, we've got a new system not yet invented that works across racial lines, works across sex lines, is really highly effective and 99.9% of the time identifies the right face, do I think law enforcement could potentially make an argument we're going to use that not to arrest you and throw you in jail, but to at least narrow down the suspects so we can work out who should be questioned in relation to the offence? I think that might be justifiable, right? I can see that in that context, law enforcement could mount a case for using facial recognition technology. The truth is we're not there yet. And the current systems, it would be inappropriate to use for a whole variety of reasons.
So I think in the interest of time, since we are running out of time, we have to stop the question answering at this point. I would like to thank Professor Moses again for the wonderful talk and the answers to the questions, which is really insightful. Thank you very much, Lyria, for your time.
Thank you very much for having me.
Okay, and I think you remember, right? So we have a session with the organizers with that immediately after that. So please join to that session. Okay.
Okay. Arindam, can we continue with some of the session? I mean, some of the questions a little bit more. There are many questions.
Yeah, I wanted to, but I was not sure about whether we should continue about that. Should we do that? I am happy to do that.
Let's continue this session because there are several questions which.
Yes, I know that. So, okay, then because I am happy to continue actually.
Sure.
Okay.
I'm happy to continue. That's fine.
Okay, so the next question is from Abhishek Das. So Abhishek is asking, my question is regarding drafting and operationalization of the policies regarding AI systems. How do you envision government and policymakers and these tech giants get along for the greater good of the society? The question might be of interest because often the policies and their implementation might have huge gaps to cover. For example, new IT rules in India, WhatsApp claims implementing some part of which may violate rights to privacy. FDI in e-commerce policies in India asking to provide a fair playing field without defining it whatsoever, etc. So
that's a very big question, and I don't have the background on all the relevant Indian law, IT rules in India and so forth. So maybe I'll just answer it at a very high level. If I go back to the sort of first part of the question, how should government and policymakers and tech giants, work for the greater good of society? Ultimately, that's through law reform. So I think the biggest thing we need to do is actually get things like competition law right. because I think a lot of the time competition law doesn't really understand the ways in which the platforms that are being created now can dominate and have dominance in a particular market in ways that are much harder to overcome than perhaps sort of traditional kinds of firms. So we can think about that. We can think about consumer law, right? So to what extent do particular products have to come with particular kinds of guarantees? And we can think beyond the sort of issues consumer law deals with now to other questions. We can think about, when you talk about the right to privacy. In Australia, there's a huge amount we can do with our privacy law. At the moment, there are very few private rights of action where there's a breach of privacy, right? People can't do anything. I've got lots of ideas for reform in that area that'll take me far too long to talk through. But, there's a lot here we can do for better laws, that we can do that often at a very general level without, formulating an IT law, for example.
Okay. The next question is.
Can I interject? I think
Sure.
there are many questions, and this. So one suggestion that I have is, if Professor Moses, you were happy with it. So we will archive all the questions and we can send it to you. And maybe in your leisure time, you can answer, and then we can distribute it to the participants.
Sure.
That we can work on?
Yeah, no problem.
Okay. So because, I can see there are lots of questions coming in. It will not finish in any, any quick amount of time now. And we have another session coming up. So, to all the attendees who have asked the questions, so this is the mode that we will follow. We will archive all the questions, send to the speaker, and she will reply in a leisure time, and then we will distribute the answers. Is that fine with everybody? That's fine with the speaker, right? Okay. So
yeah, that's fine by me.
Okay. All right. Okay.
So in that case, we'll